The defense is wrong. That was a phrase uttered by Marisa Tomei in the movie My Cousin Vinny, as she plays the automotive expert trying to explain why the prosecution's argument, or actually the defense's argument, was totally wrong. My question for you is, when you bring a medical malpractice case in New York and you believe you have the best medical expert around, does that mean that this medical expert is untouchable? Does that mean that there's no way for this medical expert to get chopped down on cross-examination during trial? You want to know the answer? Come join me as I recite for you one or two other phrases during the movie My Cousin Vinny as I explain to you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. If you have not yet seen the movie My Cousin Vinny, it's a great movie to watch. It's a great courtroom drama. It's a comedy. You've got some great actors, Joe Pesci, Marisa Tomei, and some other really great actors, especially the judge, Judge Halloran, who you may have known from other shows, including The Addams Family. But in any event, let's go back to the question that I raised. You believe you have a solid case. You believe that your doctor was careless and caused you significant harm and injury. And now, before being able to go forward with a lawsuit, your attorney had to hire a medical expert to evaluate whether or not you truly did have a valid and meritorious case. After a few months, your attorney comes back to you and tells you, yes, he found the best medical expert in the country who reviewed all of your records, who determined that, yes, your doctor was in fact careless. He determined that that carelessness was a cause of your injury. Remember, it doesn't have to be the cause. It only has to be a cause. There could be multiple causes. And this expert has determined that your injuries are significant and, in fact, permanent. So now the defense refuses to acknowledge they did anything wrong. The defense says that they are never going to offer a dime in trying to negotiate this case because they believe nothing was done wrong by the doctor. And even if it was, guess what? They don't believe your injuries are significant or serious. So they have no intention whatsoever of entering into any settlement discussions. Okay. Now your case goes to trial after 2 long years of litigation. You are at trial. And remember, when we go to trial, it is our obligation, the attorneys who represent the injured patients, we are known as the plaintiffs. As the plaintiff's attorney, as the attorney who represents the injured patient, it is our obligation to put on all of the proof necessary, including medical experts, doctors, other witnesses, as well as medical records and documentary evidence, to establish that we are slightly more likely right than wrong than what we are claiming is true. That is our obligation. So now we bring in the best qualified medical expert in the entire country. We know he's great. We know he's got 60 pages worth of publications. We know he's the leading expert in the entire country on this particular area of medicine. And there is nobody better in the world. And you are confident. You are confident that the jury is going to recognize this. Your attorney is confident that the jury will recognize his expertise. And now you are so overly confident, you forget one thing, that the defense will have an opportunity to cross-examine this particular witness. Now, there's something else you should know. When a case goes to trial and the opposing side, the defense attorney in this case, has an opportunity to cross-examine an expert, there are a number of different strategies that will be used to try and show that this expert is either being less than truthful or doesn't have sufficient information to reach the conclusions that he reached, or that there's something else in his background that could conflict with the testimony he's giving today in court. And so there are many different strategies and different ways to try and show that this expert may not be as credible as once thought. So your attorney and you and the medical expert all believe that they are solid and on good ground to go forward with this particular claim. And now the doctor goes ahead and testifies on direct examination. What does that mean? It means that your attorney questions him at length, asking him many open-ended questions. He's going to teach the jury about this area of medicine. He's going to explain to them what good medical practice requires, and he's going to then take them through step by step to establish why the treatment that you received was inappropriate and in fact deviated from the standard of care. And as a result of those departures from the standard of care, you suffered significant harm and injury. Now, I promise you that by the time your expert is done testifying, you are going to feel great. You're going to be uplifted. You're going to feel so confident that there is no possible way you could ever lose your case. And then, just wait for it. Then there will come a time where your attorney will say, "Thank you, doctor, no further questions." And now it will be time for the defense lawyer to stand up and begin to cross-examine this particular expert. Don't think for a second, no matter what experience this defense lawyer has, that it's going to be a shoo-in, that it's going to be a lock, that this expert can't be touched and can't be destroyed on cross-examination. If you were to think that, you would be 100% incorrect. I have seen great experts up on the witness stand who have been cross-examined and literally torn to pieces in very subtle ways by establishing things that they never thought of or never expected. And that is the danger associated with cross-examination. An attorney who gets up to cross-examine a witness has in all likelihood done a tremendous amount of research and, importantly, preparation. And the preparation involves not just trying to obtain dirt on this particular expert, but also obtaining transcripts of other cases the doctor may have testified in, and speaking to other attorneys who have had the opportunity to cross-examine this particular expert, and digging and doing their own research. And the goal is to try and find dirt on this particular doctor. It might be something so simple as having put down something incorrectly on a form that he filled out for an application for hospital privileges. It might be something so simple as lying about the fact that he derives a substantial amount of income from doing these legal expert reviews as opposed to actually treating patients on an ongoing basis. The smallest little lie or inconsistency can tear down a great expert. So don't believe for 1 second that just because your expert has the best qualifications and has testified 20 times before, that he is untouchable. The reality is that he's not. And if an opposing attorney is able to find some good dirt on the doctor, now he has great ammunition to establish that this doctor's testimony may not be that reliable. And ultimately, it will be up to a jury to decide whether this doctor is credible, whether he is believable. No matter how many awards or how many papers he's published on this particular field of medicine, no matter what type of respect he has earned from his colleagues in this medical community, it all comes down to one thing. Is the expert credible? Is he believable? If the jury believes that he is credible, they will disregard what the defense had to say. And they will disregard whatever ammunition they had to try and establish that this guy was not credible. On the other hand, if that little piece of evidence that comes out turns the tables, and now this doctor's credibility is shot, it doesn't make a bit of difference what his medical experience was. It doesn't make a bit of difference whether you believe the medical testimony by the doctor is 100% accurate. The fact remains that it is up to the jury to ultimately conclude whether this expert is credible. So why do I share this quick information with you? I share it with you just to help you understand how these types of medical malpractice cases work in the state of New York. You know, I recognize you're likely watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.